Today we're talking about Texas Penal Code 8.08. It is lack of capacity for a child. Let's take a look at the statute and we'll go over some of the highlights. 8.08 comes right after 8.07, which may not be surprising, but 8.07 is age affecting criminal responsibility. It talks about two provisions specifically that, and let's look at those. A person may not be prosecuted for or convicted of any offense that the person committed when younger than 15 years of age, except for a misdemeanor punishable by fine only. That's subsection A4. And then subsection A5, a violation of a penal ordinance of a political subdivision. So this is like traffic tickets. You can still have criminal responsibility for speeding, for example. All right. So 8.08 says when we're looking at those things, this is what we should consider, okay? Subsection A for 8.08 says, on motion by the state, meaning the prosecutors, the defendant or the defense attorney, or a person standing in parental relation to the defendant, or on the court's own motion, meaning like the judge's own motion, a court with jurisdiction of an offense described by section A4 or 5, those are those class C level offenses, shall determine whether probable cause exists to believe that a child, including a child with a mental illness or developmental disability, one, lacks the capacity to understand the proceedings in criminal court or to assist in the child's own defense and is unfit to proceed, or two, lacks substantial capacity either to appreciate the wrongfulness of the child's own conduct or to conform the child's conduct to the requirement of the law. If the court determines that probable cause exists for finding under Section A, after providing notice to the state, the court may dismiss the complaint. A dismissal of the complaint under subsection B may be appealed as provided by 4401 of the Texas Code of Criminal Procedure. 4401 is a state's appeal, and that is very rare, certainly on a Class C level offense. When there's like the potential of existence for a mental disability, that's going to be really unlikely that it gets appealed. So what does this all mean? In plain English, it means that if you're a 14-year-old child, because it's got to be less than 15, right? In here, if your 14-year-old child has a mental illness or a developmental disability, they're going to be treated like this is like an insanity defense for that, okay? Except in the insanity defense, the criminal defendant has the burden of proof, the burden of production and persuasion, meaning the defendant has to be the one that produces or shows the court that there has been evidence produced that shows that maybe the defendant is mentally ill or doesn't understand that his conduct is wrong. We call that like a modified McNaughton test. If you're a criminal lawyer, you can look up the McNaughton test. It means you don't understand that your conduct is wrong. And that's different from like an irresistible impulse version of insanity defense, which some other states have. We don't have that in Texas. We have this modified McNaughton. It says in the insanity defense, it would say because of a mental disease or defect, you don't understand your conduct is wrong. But this one's a little different. It says you don't appreciate the wrongfulness of your own conduct or you have the ability to conform your conduct to the requirement of the law. And the key difference is that if there's probable cause that this exists, the judge can dismiss the case. And that is very different. In a criminal case, like for a regular adult criminal case, insanity would require proof basically from the defense by a preponderance of the evidence convincing the jury that you're insane. This one is just, does the judge believe probable cause exists? And so that's a very much lower burden. It's only applicable in Class C cases against minors. So it's going to be tough to find a good applicability for this one. But if you're a nerd and you're interested in the law, this is a great one to know. There's a special insanity defense for minors in Class C cases in Texas. It's Texas Penal Code 8.08.